All right, I think we can get started. Other people might still join us, and that's fine. So it looks like I didn't scare away too many people from, from this morning. And so I do want to acknowledge the chair of our commission, Motoko Aizawa, has joined us. She's our chairwoman of the DC Commission on Human Rights. So we're going to continue with talking about some evidentiary issues. Spent a lot of time on hearsay, but there's a lot of other evidentiary issues you're going to have to face in administrative hearings. But one thing about excluding evidence, you have the absolute right to reject evidence, again, if it's irrelevant, if it's immaterial, if it's unduly repetitious, then that's reasons to say I'm not going to allow this particular testimony or document into evidence. But you do want to give the witness or the attorney a chance to make a proffer if you're not going to allow the evidence in. Because if they want to appeal that decision, if they say, you know, that piece of evidence was crucial to making my case, and the administrative law judge or the hearing examiner didn't allow it in, you want to have something for the reviewing court to agree with you that it was right to put it out. So the way you do that is you go ahead and allow them to make a proffer. And that is either you can allow the witness to say, well, this is what I would testify to if it was going to be allowed in, or you allow the attorney to say, if I was allowed to call this witness or if I was allowed to offer this document, this is what it would reflect. And then it allows the reviewing court to consider if they want to raise that on appeal, whether or not it was properly kept out of evidence. So always feel free to let the parties make a proffer if you don't allow something to come into the evidence. Documents also are something that are often fought about in administrative hearings. And there's a lot of objections to documents. Now, obviously, documents almost are always going to have hearsay in them. It's rare that you're going to have a document that only speaks directly to the point that the person is trying to offer it for. So the question is always, do we let the whole document in, or do we have to say, okay, we're only going to let paragraph 1? Well, how do you just, am I supposed to white out the rest of it? I mean, how do you just let in a paragraph? And again, it goes to you being the fact finder. You understand that there are reliable parts of the document and there are unreliable parts of the document. And the parties have to trust that you're only going to focus on the reliable part of the document when you allow that document into evidence. But when there is a hearsay document, there does need to be a foundation for that document. You know, what does it purport to be? Why am I offering this into evidence? Now, when it comes to documents, most of the time, documents are going to fall into the traditional business records exception of the evidence rule. And so that's a time where you might want to go ahead and rely on the rules of evidence and let them just lay the proper foundation for allowing a document in. But if it doesn't fall within the traditional business records exception, you can still let it in. Because, again, hearsay is admissible. The rules of evidence don't apply in administrative hearings. And everything else goes to how much weight do you give that document that doesn't fall into the traditional exception. So if there's other testimony that can establish that the document is accurate, then it's a completely reliable document. Go ahead.
So I was going to ask about the authentication of the document, whether it's audio or whatever it might be. Is there a standard?
There's not an official standard because, again, under the APA, any evidence can come in. So you only have to believe that it's reliable. But when you're dealing with the business records exception, then you would have to have somebody who says, you know, I'm familiar with the document, it's kept in the regular course of business, we're in the business of keeping documents like this, and I can certify the truthfulness of this document. But you don't have to have that level of a foundation in an administrative hearing. But you have to have somebody who is at least able to say what this document is, where this document was kept, this document was not altered, and there's a reason that I'm offering this document. So it doesn't have the same high level of a burden to get a document in an administrative hearing. But if they don't have that foundation, then it's not going to be a reliable document. You don't have to let it in. It's completely at your discretion, and you have to be really careful when you're dealing with anonymous documents. Courts don't like anonymous documents. You have to know where this document came from, who wrote it, who does it belong to, where did it come from. It can't just be some, I've had cases where, somebody brought in a note. Well, I don't know who wrote the note, but I found the note in this file. That's anonymous, and that's not strong evidence, and I probably wouldn't allow something like that to come into evidence. I'm not moving. Oh, there it goes. Okay, investigative report is probably one of the biggest documents that are argued about at the hearing. Now, you might have a rule in your local Administrative Procedures Act or in your human rights law. You might have a rule that deals with documents. A lot of jurisdictions do. We don't. In DC, we don't have any specific rule that tells us what kind of documents do and don't come in, or what the investigative report is. Now, one of the things that's interesting, at least about our investigative reports, is what our rules do say is that the investigative report is confidential, that it is not to be made available to the public, and it is not part of the commission record. So when a case comes to us, we do not have the file, but we do have the report. The report is all we get. We get the letter of determination. It's the investigative report. But it's not technically considered part of the record unless it's been offered into evidence at the hearing. It's not automatically part of the hearing record. So the question often becomes, people will try to keep that investigative report out of the record because of all of the hearsay that is in it. And they'll try to keep it out because it has opinions sometimes. The investigator might have put their opinion into the report of what happened, or the conclusion. And now, this is a de novo hearing, so the conclusion of the investigator doesn't matter. We don't rely on the conclusion of the investigator when it comes to the administrative hearing. So these are all reasons that you're going to get objections. The other objection that you're going to get to the investigative report is that we have no opportunity to cross-examine the witnesses whose statements are in the investigative report. But that's not true. You've got the report, and you've gone through discovery. So when you go through discovery, it's very reasonable to assume that this investigative report might come into evidence in the hearing. So it's your responsibility as a party in the case to subpoena that witness if you think you're going to need him, or to depose him. That's your opportunity for cross-examination. So you always have an opportunity for cross-examination of those witnesses. But in addition, when you're talking about administrative hearings, there is no Sixth Amendment right to confrontation. So that's what keeps documents like this out of a traditional trial. If you don't have the witness there who you can cross-examine and say in a criminal case, that document, when something like an investigative report, would never come in to evidence if you couldn't call the witnesses to repeat those statements and to cross-examine them. Because in a criminal case, you have a right to confrontation, and that's where cross-examination comes in. You don't have a right to confrontation in civil cases or administrative hearings. There's no Sixth Amendment, but people will make that argument to you. They'll make the argument at your hearing, objection, I haven't had the ability to cross-examine these witnesses, and I have a Sixth Amendment right to do so. No, you don't. There's no Sixth Amendment right in administrative hearings, only in criminal cases. So the other thing about the investigative reports is even though they contain hearsay and even though they contain opinions, they are government records and they are presumptively reliable. Any government record has a presumption of reliability. Now you can prove otherwise. The parties, it's their burden now. It's not your burden to say it's reliable. It's their burden to prove it's unreliable. It's presumptively reliable, and you can allow those investigative reports into evidence. The same with police reports. They're presumptively reliable, and it's the burden on the party to show that they're not reliable because they are government records. And it also says in this in Richardson versus Perales case we talked about this morning, parties who fail to exercise the right to subpoena a witness have effectively waived the right to complain about a denial of the opportunity to cross-examine. you have the burden, you know that's possible this can come into play, you have discovery, that's your chance to cross-examine those witnesses that have been interviewed in that investigative report. You should have subpoenaed them, you should have deposed them. And if you don't do that, you can't wait to come to the hearing and object then and say, I don't have a chance to cross-examine them. And the Supreme Court has held that it comes down to, again, we've said that this morning, integrity and fundamental fairness. Is there anything fundamentally unfair in this report that's so prejudicial to one side that you shouldn't allow it in? If not, it comes into evidence, and you can treat it as reliable. And we don't apply the rules of evidence, but if you are applying a traditional business records, there's an exception for public records. And this is Federal Rule of Evidence 803-8C. It applies to public records and reports. Statements or data compilations in any form of public officers or agencies setting forth in civil actions and proceedings and against the government in criminal cases, factual findings resulting from an investigation made pursuant to authority granted by law, unless the sources or information or other circumstances indicate lack of trustworthiness. Government investigative reports of factual findings, that's what your letter of determination is, your probable cause finding. It comes under the exceptions for public records under the Federal Rules of Evidence as well. It comes into evidence. And that lack of trustworthiness, that burden is on the parties, it's not on you. And so you have to consider what's the purpose of the report. What's it being offered for? It does not serve to prove facts. You know, you do need a witness to prove the facts. You're not going to take the investigative report and say that, you know, that's almost double hearsay. You know, they told the investigator, or someone told them and they told the investigator, and this is what the investigator found to be true. So it doesn't necessarily prove a fact in the case. But what the reports are most commonly used for is to challenge the credibility of a live witness. So somebody has said one thing to the investigator, and now we're at the hearing and they're saying something else. That's the most probative value of bringing in those investigative reports. Are we getting testimony at the hearing that's consistent with the information that was given to the investigator when they were doing their probable cause investigation? And that's the main reason parties are going to want to bring that report into evidence at your hearing. And again, it can be excluded if it's untrustworthy or the presidential value outweighs the probative value. And it is the party opposing admissibility that has the burden of establishing any negative factors to that report. All you have to believe is that there's a foundation for it and there's a reason for it to be reliable, and that makes it come into evidence. And then again, business records, the rationale underlying the business record exception is because businesses rely on records. I mean, businesses are all about records. So it's important for a business to keep accurate records. And that's why we say they're presumptively reliable. Now, of course, businesses can alter records. It happens. But then the parties have to prove that. We don't assume that a record has been altered. We assume a record is reliable, and then we put the burden on the parties to show there's a reason that it's not reliable. But if you're relying on the traditional business record foundation, this is what the parties have to show, that the record was made in the regular course of business, that it was a regular course of business to make such records, that the record was made at the time of the act, transaction, occurrence, or event, and that the original maker has personal knowledge of the information in the record. Now, in an administrative hearing, they don't have to have personal knowledge. That's one of the big differences between getting a record in a traditional hearing and an administrative hearing. They don't have to have personal knowledge of the contents. They just have to be able to tell you where it came from and that it's an official record to make it reliable. Now, there is a question that comes up for us a lot, which is, are they automatically admissible or do they have to come in through a witness? We generally do not require them to call the investigator in order to get the document into evidence. And the reason we don't require that is because once the case is certified for a hearing, the Office of Human Rights is going to provide all parties with a copy of the administrative record. So every party has received the report directly from the agency and have it in their possession. And so there's no reason, and what happens when you do call the investigator, we really, really try to avoid having the parties, they will try to subpoena them, and we will almost always quash those subpoenas for the investigator because it doesn't matter. It's a de novo hearing. You don't want to spin your wheels at a hearing talking about what the investigator found. It doesn't matter what the investigator found. You've got to find the facts yourself. So why spend an hour raking the investigator over the coals about their findings when you're not relying on what the investigator found? So we do allow them just to offer the report quite often without a witness from the Office of Human Rights to put the report in, because it's an official business record of the agency. And again, some jurisdictions, check your rules. You might have specific rules for business records. I've seen a lot of jurisdictions. I know Maryland, for example, does have some specific rules for business records. Most of the federal agencies have specific rules for business records, or your rules might be silent. You want to always focus on whether it's credible, probative, and reliable, just like you would focus on the oral testimony. It's the same standard. Is it reliable? Is it probative? Is it credible? And then there is something called the silent witness theory of admission. And this is an alternative way to get evidence such as photographs into evidence. Because again, there are, if you're dealing with the rules of evidence, there are certain foundations that you have to lay in order to get something like a photograph. They have to be able to say that it accurately depicts the scene at the time, that it hasn't been altered. And again, you don't have to do that in an administrative hearing. And under the silent witness theory of admission, photographic evidence may draw its verification not from any witness who actually viewed the scene portrayed, but from other evidence which supports the reliability of the photographic product. And so you can actually get photographs into evidence without having to go through the traditional foundation that you would in a traditional hearing, which makes things a lot easier. Again, is it fair? I mean, it's only if it's prejudicial and unfair. If someone really can't say where this photograph is, so people will really argue about, well, when was the photograph taken? What time of day was it taken? You don't have to get into that kind of minutia when it comes to photographs in an administrative hearing. All right, and then another way that evidence issue is what we call judicial notice or official notice. And these are facts that are outside of the hearing record. And I don't think I've ever had a hearing where somebody did not ask me to take official or judicial notice of something. There's always something that comes up that they want you to take official notice of. And quite often it is dealing with other cases, or something that has happened, maybe another letter of determination, or something that happened in a different case. And they want you to take judicial notice of that because they want to argue that you're bound by the same decision that previously occurred. But there is a difference. It's a slight difference. The terms are often used interchangeably, but really they're slightly different in that judicial notice derives from the rules of evidence. And it's generally limited to matters of common knowledge, like the weather, the date, the time. Very common knowledge, things that are very, very easy to prove and look up, things that are not debatable. And that comes from the rules of evidence. Official notice, however, is much broader than judicial notice, and it comes from the Administrative Procedures Act. Official notice was specifically derived for administrative hearings. And it allows the agency or the administrative court to also take notice of technical or scientific facts that are within the agency's area of expertise. So if your area of expertise is the tax law, if that's your agency, then it allows them to take official notice of certain things that are commonly known within the tax community. And that's not something that would happen in a traditional court. And so with judicial notice, it's a rule of law of evidence that allows facts to be introduced into evidence if the truth of the fact is so notorious or well known that nobody can question it. It's very simple, very basic facts. And here's an example of the simplest, most common sense facts, such as which day of the week corresponded to a particular calendar date or the approximate time of sunset, things like that. You could take judicial notice of that. We don't have to argue for 20 minutes about what time something might occur. If someone says, well, it was close to sunset, and then they're saying, well, what time was sunset? And one person says 5 a.m. Well, I think it was 7 a.m. Well, we can verify that. We can figure out what time the sun set on June 1st of 1969. That's undebatable, and that's okay to take judicial notice of something like that. And these are some examples of official notice, and this is from a case. It's a case of Hinkle versus Hartel, but it is literally, if you look at the case, this judge listed 2 pages of things that he thinks are okay to take judicial notice of. So again, the public law of states. We can look up the law. Someone will very often say to you, take judicial notice that DC Code section whatever says this. Okay, that's fine. I'm going to take judicial notice of that. We can verify that. We can verify what the law is. The laws of nature. We lightning struck and we had to go indoors. That's something that it's pretty reasonable. I'll take that. I'll take that statement, and I'm not going to argue with you about the truth of that statement. Days of the weeks, months in the calendar, things like that, all fair game for judicial notice. But official notice, again, much broader, and allows the hearing officer to take official notice in the final adjudication of certain facts outside the hearing record. That's what it says in both the federal APA and in our District of Columbia APA, both specifically allow for official notice. It's matters of common knowledge, matters that can be verified by sources whose accuracy cannot reasonably questioned, general, technical, or scientific facts within the specialized knowledge of the hearing officer agency. And very importantly, an agency can take official notice of its own records. And that comes into play a lot. You can take into things that have been submitted. For example, people file motions, and maybe they've filed, you've ruled on that motion, there's some documents attached to that motion, and they'll ask you, can you take official notice of this Exhibit B that was filed with this motion? It's in the record. That's okay, because it's part of our record. And so we can always take official notice of your own record. And so what do they mean by technical or scientific facts in an agency's area of expertise? And what the DC Circuit has said is the logic behind this expanded scope of official notice is that since administrative agencies necessarily acquire special knowledge in their sphere of activity, certain highly technical facts may become to the administrators as obvious and notorious as facts acceptable to judicial notice are to judges. So they're distinguishing official notice from judicial notice. Judges in the traditional court take judicial notice. Administrative law judges and commissioners should be taking official notice of facts, not judicial notice. But this does not authorize the agency to use its expertise to compensate for the absence of key evidence not presented. It's just for those commonplace things that we just don't need to argue about, but you can't fill in missing facts with official notice. Like, you didn't meet your burden, so let me meet it for you. That's not what official notice is going to be for. And so there are procedures, though, attached to taking official notice. And this is only if you're going to rely on that official notice in making your decision. So if you've taken official notice something and it's a material fact that is going to be part of your decision, the party has and is entitled to an opportunity to show the contrary. So you have to say in the hearing that you are going to take official notice, and you have to give them the opportunity, and it doesn't necessarily have to be at the hearing. It might be that they need to file a brief. It might be that they're going to do it in their closing argument, written closings or proposed findings of fact or conclusions of law, but only if they request it. If they don't request it, it's a non-issue. But they have the right to request, to oppose your taking official notice of something and be able to submit something on that. And again, the hearing officer must note in their order that they are taking official notice of material fact. So now we're going to move to hearings and what's things that are going to go on at the hearing. So we said this a couple of times, and someone had a question this morning. When you're adjudicating human rights complaints, they are de novo hearings. And when we say de novo hearing, and for us, whether it's a public sector or a private sector case, it's a de novo hearing. And what that means is that we're making a decision without relying on anything that happened before the case came to us. We are not relying on the probable cause finding, the letter of determination, the investigative report. Now, we look at those things to see what the case is about, but we don't treat them as facts that have been proven in the case, and that's what a de novo hearing means. But we don't disregard it, and it's especially important when you're at the summary judgment stage. I know that, and the Court of Appeals, they don't like, in administrative hearings, they don't like summary judgment. Even though we know a large percentage of district court cases are dismissed by summary judgment, the courts of appeals really don't like to see administrative cases dismissed in a summary judgment stage unless the evidence is super, super strong that a complainant cannot meet their burden. So in our cases, what we've seen going to the Court of Appeals is they have reversed summary judgment findings based on the letter of determination. So they have said, well, the letter of determination, though, says X, Y, Z, and you didn't consider that in summary judgment. Well, I didn't consider it because they didn't raise it in summary judgment. So in a traditional court, that probably would be fine, but in administrative hearings, the Court of Appeals, they will look at the investigative report and see whether, in granting summary judgment, could they have met their burden in any of the claims that were made there? And if you didn't address that in summary judgment, they're going to reverse and remand that case. So you have to be really, really careful in administrative hearings with summary judgment. The courts don't like it. The courts feel that, complainants should get their day in court. All right, so in an evidentiary hearing, we follow the traditional format. And in an evidentiary hearing, we have opening statements. Don't be afraid to limit the time in your opening statements. Again, there's no jury. Opening statements for the jury. By the time I've gotten to trial, I have ruled on 20, 30 motions in these cases. I've had show cause hearings. I've had motions for sanctions. I've had the parties. I know what the case is about. I know exactly what the case is about. But, I also acknowledge, a lot of times we have young attorneys, we have attorneys who are maybe trying their first case and they just need to go through the process. And that's fine. I'm going to let you do that. But I am not having a 1-hour opening statement. I will very clearly say, if you want opening statements, you've got 15 minutes. That's it. Then I've got 3 parties. That's 45 minutes. I got 15 minutes for each party to give an opening statement. That's plenty of time. Don't feel that you have to let people give unlimited opening statements because you know what the case is about already. And then we have direct and cross-examination. Now, how you handle this, I think, depends. It can be complicated when you've got 3 parties, and not everybody has 3 parties. And so there's a lot of repetitiveness, and you have them calling the same witnesses. So a lot of times we will go outside of the traditional order of an offer of proof. So normally you'll have, the complainant is going to put their case on first, and then the respondent, and then maybe the agency. But if they're all calling the same witness, I am not going to make that witness come back on 3 different days for 3 different parties to question them on direct. So we will move away from the traditional order of proof at that point, and I will allow each of the parties to do their direct examination back to back of the same witness, and then their cross-examination. So it can get confusing, gotta control it, but you don't want to really wear the witnesses out and have them coming back over and over and over again. So I try really hard anytime to have a witness to make them come one time and one time only, unless they're, have to testify for multiple days. So we have, the complainant puts their case in chief on, and then usually the agency puts their case in chief on after the complainant, and then respondent puts their case in chief, and then we have rebuttal, if any, and then closing arguments. Most of our closing arguments we do in writing. I leave it to the parties, whether they want to do it orally or in writing. Now, if it's a pro se litigant, they're not going to want to do it in writing. That's a lot to ask of a pro se litigant, and they probably aren't even going to do it orally. Most of the time, a complainant is going to forego a closing argument. But the agency will often do that closing argument on behalf of themselves and on behalf of the complainant in our cases. But most of the time in our cases, the parties choose to do written closing arguments. And then we also, depending on the complexity of the case, will ask the parties to do proposed findings of fact and conclusions of law. And again, that's at your discretion. If it's a very simple case, I don't ask for it. But most of our cases, our trials on average go 3 to 4 weeks for a single trial. So it's a lot of things that come into evidence, and you can miss stuff. You know, it's just a lot. And so it helps to fill in the gaps when you see what other people are proposing as findings of fact. So I do always ask in the more convoluted cases that both sides submit proposed findings of fact and conclusions of law. So direct examination, we follow traditional trial practice, no leading questions. And that's a fundamental fairness issue, because if you ask a question in a leading way, which means that you are implying the answer, then it becomes a very unfair proceeding. So we do follow the traditional no leading questions on direct examination. So a lot of times people resort to something like, would it be fair to say that on January 1st, that's a leading question. We don't like that. As soon as I hear the words, would it be fair to say, I'm like, nope, stop, rephrase it, stop right there. Because most of the time the complainant's not gonna object when they hear that, because they don't know. They don't really know the difference between leading and non-leading questions. So, you know, that's part of making sure you protect the procedural fairness of the process. You know that a complainant who's not represented doesn't have the ability to object on those grounds. So I'm not just going to allow an attorney to run off with leading questions and, you know, trample over the pro se litigant in a hearing. And also making a statement and asking, is that correct? That's a leading question, and I don't allow the parties to do that either. So just an example, if you're not familiar, you know, a non-leading question would be, you know, what were you doing on the evening of October 1st, 2021? But a leading question is, isn't it true that you were home watching television on the evening of October 1st, 2021? That implies the answer. You're giving me the answer. If I can answer the question with yes or no, it's a leading question. And so questions about exhibits. This is something, area that even attorneys often struggle when it comes to asking questions about exhibits, especially when you have another attorney constantly objecting. And we've got a lot of really good objectors who appear before us, and they do it to throw you off your game. And they do it to other attorneys, and they do it to unrepresented litigants, just to frazzle them if they're constantly objecting to, you know, what you're saying or what you're trying to get in. But particularly with documents, so if the attorney's purpose is to ask questions about the exhibit, what they need to do is offer the exhibit into evidence first. So a big mistake the attorneys often make is they want to ask questions about the exhibit before they offer the exhibit into evidence. And that's objectionable. But once you've offered the exhibit into evidence, the exhibit speaks for itself. So at that point, it's fair game for the attorney to just read from the exhibit, because the exhibit is now in evidence, and I'm going to read the exhibit. So if the agency staff, this is just an example, there's no need to use the witness, because a lot of times they'll say, you know, you'll give the document to the witness. You know, can you find in this document where it says X, Y, Z? And the witness is like, oh, I don't know where, you know, it's okay to turn to that page, give that to the document, to the witness, and say, you know, I'm drawing your attention to the second paragraph of page 5 of this document. Can you read what that says? And then ask a question. That's all they have to do. They get really, really caught up in how to ask questions about documents, and it can really be simplified. All right. So then we have facts not in evidence. This is another one of my favorite questions. Would it surprise you to know? That's testifying. It's the same as testifying. That's not, I don't allow them to ask the question, would it surprise you to know? Because this is what attorneys do to reveal a fact that they haven't been able to get into evidence. They're trying to get it out. It's not in there. They haven't been able to get the witness to say what they want them to say. So then they say, would it surprise you to know that on January 1st, this person was seen drunk? And now they've just established, well, they think they've established something that they weren't able to get into the record through the witness. So you have to be very careful about that. Nothing the lawyer says is evidence. They can't testify. And a lot of times lawyers they'll try to interject, they'll try to clarify the response. The witness will answer and the lawyer will say, well, let me explain. No, don't explain. Don't explain to me, ask your next question. You don't get to do that. The witness gets to speak. You can't analyze for me what the witness should have said. I heard what the witness said, and I'll have to decide what that means. A witness is not entitled to answer a question that was not asked. For some reason, we've gotten to this belief that witnesses are allowed to explain their answers. They're not. They don't get to explain their answer unless I ask them to explain their answer, or the attorney asks them to explain the answer. If I say why, then explain it. If not, you're stuck with the answer they gave. And then what happens is the other side jumps up and says, well, that's not fair, let them explain. No. When you get to cross-examination, you can clarify. That's your job on cross-examination. You come back and you clean it up. But you don't jump up in the middle of someone's direct questioning and say, no, let them explain, that's not what they meant. It doesn't work that way. That's not how we handle things. But as the hearing examiner, the commissioner, you have that discretion, though. If you want them to explain, there are times when you, as the fact finder, want them to explain. If you want that, then let them explain. They're like, I don't understand. I need more information from what you're saying. That's okay. You're free to do that. And then you have expert witnesses. The times that, at least for our cases, where we see experts, medical testimony, and that usually is related to whether someone has a disability or what the impact of that disability is. We see it for compensatory damages. So if somebody's claiming emotional distress, mental health, they call an expert to talk about how the situation has physically manifested itself on the complainant to entitle them to compensatory damage. Job market analysis, mitigation of damages for someone who's maybe terminated and then has been unemployed for a long period of time. Did they effectively mitigate damages? They look at job market analysis, what's the job market like in the area? What's the average salary? What based on this person's employment history, were they employable? The people will call an expert to stuff like that. So those are the areas we most commonly see experts. Administrative agencies have great discretion to allow expert testimony. You are not bound by, again, the federal rules of evidence. You're not bound by Daubert. You're not bound by Fry unless you have a specific rule applicable to your jurisdiction that says this is what required for an expert. They're just another witness. And remember what the APA says? Any testimony comes in, and that includes experts. It comes down to, again, is it credible? Is it reliable? Fundamental fairness, due process. Does it meet those things? Then it's perfectly fine to allow that expert to testify, and you don't have to go through the Daubert analysis of, is it generally accepted in the scientific community? Has it been tested? You don't have to go through that if you don't have a specific rule in your jurisdiction that requires you to go through that.
Excuse me. Is emotional distress given a monetary value for compensation?
It's not given a monetary value in the rules. It's completely discretionary. And we rely a lot on the EEOC findings. And it's not that they even have a formula, but you just can kind of see a pattern with the EEOC as far as how severe the consequences were. The more severe, the higher the penalty. Oftentimes the award is kind of low, $1,500, $3,000. We don't really see a lot in the millions when it comes to compensatory damages. Other thing to be aware of when you're dealing with experts, a lot of times what we see is you have the complainant's going to call their treating physician, and the respondent is going to just call an expert that they've hired for the purposes of this litigation, who's never examined the complainant, but they've reviewed the complainant's medical records. And what the court has said is that in reviewing medical evidence, the ALJ must give preference to the conclusions of a treating physician over a non-treating physician who is retained to examine complainants solely for the purposes of litigation. You do have to give a little more credence to the treating physician. Now, doesn't mean you have to believe him. Maybe he's not credible. You can still find that he's not credible. In that case, you may give more weight to the other person. But we do give more weight to a treating physician than we do for someone who's hired for the purposes of litigation. And then we have rebuttal at the end of our hearing. Many people do not know what rebuttal really is. Rebuttal is not rehash everything that we have just spent the last 3 weeks going through. That's not rebuttal. It's not. Rebuttal is evidence that refutes a new proposition. If something has been introduced for the first time during the hearing, didn't come up in your case in chief, so it's usually the other side. Now they're doing their case in chief, and now they've raised something that didn't come up before when you did your case in chief. Now you get to come back and say, I need a chance to rebut this. We need to respond to this evidence that they put on. That is rebuttal. A lot of people think rebuttal is let's rehash everything. It's not a closing argument. That's different. Closing argument is where we rehash everything that we've gone through for the last 2 weeks, not in rebuttal. So what's not rebuttal, repetition of evidence that's already presented, that's not rebuttal. If you addressed it in your case in chief, it's not rebuttal, all right? And introducing new evidence to bolster the case. So you think, gosh, I forgot to mention this. Like now it's too late. You've finished your case in chief. You can't come back on rebuttal and say, I forgot I wanted to raise this issue. Let me do it now on rebuttal. That's not proper rebuttal. So I'm going to talk about burden of proof. Burden of proof really is two standards. So burden of proof, it means that the party must prove its case to the trier of fact, which can be the commission, it can be the judge, board, whoever's going to make the finding in the case. And under the Administrative Procedures Act, what it says, also one of those very not necessarily helpful definitions, it always says the proponent of a rule or order. But the proponent of a rule or order, that's the person who wants to change the status quo, which is always going to be your petitioner or your complainant in a civil case. They're always going to have the burden of proof in these cases. And there's really two separate burdens when we're talking about burden of proof. One, we're talking about the burden of production, and that's coming forward with satisfactory evidence of a particular fact. And then the second is burden of persuasion, which you'll see referred to as a standard of proof. And that's your ability to persuade me that the facts are true. So it's really two parts when you're talking about burden of proof. So when you're talking about standard of proof or burden of persuasion, that's the extent to which the party with the burden of proof has to prove its case. And that is, for our purposes, substantial evidence and preponderance of the evidence. So again, findings of fact have to be proven by substantial evidence, and then overall the complainant has to meet their burden by a preponderance of the evidence. And that's what we're talking about when we say standard of proof or we say burden of persuasion. And when we say preponderance of evidence, we literally mean more likely than not, 51%. That's your little scintilla that tips the scales in favor of the party that's going to win. And a preponderance of the evidence, that's the default for all, well, not all, but most civil and administrative hearings. Again, there are times where clear and convincing could be the standard in an administrative hearing. It's not in any of our cases, but when I was my former position at the Office of Administrative Hearings, we had certain jurisdictions where clear and convincing was the standard. But for discrimination cases, it's always going to be preponderance of the evidence. And a preponderance of the evidence is defined as such proof as leads the fact finder to find the existence of a contested fact is more probable than its non-existence. And so then that takes us to McDonnell-Douglas, the dreaded McDonnell-Douglas burden shifting framework. And this applies only in disparate treatment cases, which are the bulk of the cases are disparate treatment cases. Like for example, if you're dealing with retaliation, McDonnell-Douglas does not apply in retaliation. So you need to make sure in your jurisdiction that you know which cases McDonnell Douglas applies, and it does not apply. It also does not apply in summary judgment. We do not use McDonnell Douglas. And it's always evolving. And it's complicated, and it's complicated for attorneys, so you know it's complicated for a pro se litigant or a layperson. And it's applicable when you have circumstantial evidence. So you don't have direct evidence. You know, when we say direct evidence, we're talking about that smoking gun. We're talking about that employer that, you know, made that very blatant racist statement. That's direct evidence. You know, circumstantial evidence is when, you know, it's those little comments that could be perceived as discriminatory. Those are the cases where the McDonnell Douglas burden shifting comes into play. And the way McDonnell Douglas works is the burden is initially on the employee to make a prima facie case showing of discrimination. And then once they've done that, they've made the prima facie cases, now they've raised a rebuttable presumption. So at this point, we're going to assume discrimination occurred. That's what we mean when we say it's a rebuttable presumption. Right now, we're going to assume it's discrimination, but the employer can rebut that. They can prove it's not discrimination. So now we shift the burden, and the burden goes to the employer now. And the employer has to show a legitimate, non-discriminatory reason for the employment action. And the important thing, I'm going to talk more about it, but this is only a burden of production. It's not a burden of persuasion, just a burden of production. They've just got to give a reason. End of inquiry. What's the reason? Doesn't have to be a good one, just has to exist. I've got a reason, and this is it. And then the burden shifts back. It shifts back to the employee to show pretext. And like I said this morning, this is where most complainants lose their case. They can't overcome the pretext. They can't show that this reason that they gave is a lie. That's very, very hard because the evidence is not in their hands. The evidence is in the employer's hands. Can they get the evidence that they need from the employer? That's really, really tough. So that's where most cases fall apart, is in the pretext stage of McDonnell Douglas. But even though you have this burden shifting, the complainant always has the ultimate burden of persuasion. It's always there. At the end of the day, the final question is, was there discrimination? That burden is on the employee to show me that there was discrimination. So when we're talking about the employer's burden to show a legitimate reason for the adverse action, the employer's burden, again, it's one of production only. They don't have to prove at this stage, they don't have to prove their reason is true. They just have to say, no, we fired him because he was late for work. No, we fired him because he was sleeping on the job. No, we fired him because he had a poor performance evaluation. Done, you met your burden. They don't have to prove at this point, they'll have to prove it at trial, but at this point, they don't have to prove that that's the true reason, just that they have a reason.
Can I
You
share
have a question?
quick story?
Yeah.
One of our investigators recently had a case, and she since complained, so it's still active. But her issue was, she had a disability, anxiety, depression, and PTSD. She had one more thing, but I can't remember. However, she was a controller at this company, and before she was a director. So the owner owned two companies, and she worked for both. So the first one she worked for, the director, and then they just kind of transferred employees into the other business, no big deal. But because her performance was poor, they took the director title away from her, and they just gave her the controller position, and she wasn't supervising anyone, so she didn't have any supervisors, any employees. Well, she went out on leave for medical leave, and while she was on medical leave, she's the controller, so they have to make sure, the owner has to make sure the bills are paid, things are, on track. So while she was gone, he had to go into her email to pay the bills and to catch up on things, and he found out that she was sending emails from the job, not just any email. These particular emails had a whole verbiage at the end, confidentiality clause. Some of the things were a lot of just financials. I don't know what they were.
But personal
Very
emails.
personal. One was that's irrelevant, but she sent emails from her job to her email and to her husband's email. He's not an employee. So they fired her. And during the interview, she tells the investigator, well, I've done this before. I'm on the call because she's upset and she wants to speak to the supervisor, so I'm speaking to her. And she's, well, I've done this before. Oh, well, do you have evidence of it? I sure do. Well, now, to me, that changes everything. Oh, RP's gonna have to answer, why did you guys fire her today and not 6 months ago? But they had a really good IMDR. And it was, hey, she's the controller, she's the only one, we had to pay the bill, we had to answer it at the end of the month. So I had to go into her email, and that's when we discovered it. So, of course, we asked other questions, do you always do this? Is this a practice? No, it's not, but we have to pay the bill, she's the only one that does it. So for that, she had no case, and she was upset. She's still upset. So upset that she's not even asking questions about the RP, she's asking questions about what we do. And I think she may have even lost her right to sue because she's so worried about the complaint. But initially, I thought maybe, ooh, she might have this might be a potential cause case. If she's like, I've done this before, and I have evidence that I did it.
If they knew about it.
They didn't know about it because she was at work, she was working. So they didn't have a reason to go into her emails. It was a sticky one. I had to
Yeah,
get the attorney in.
that's
They're like, no, that's not a case. So yeah, she was really upset.
I bet.
And the burden was on her to prove.
Yep. And it's hard.
It is hard.
It's super hard for a complainant to prove that pretext.
And she had an email that said, I have suicidal thoughts, and my anxiety has never been this bad. So I had to explain to her, yeah, they probably should have maybe done a little bit more with you, but they did do the interactive, hey, you want to take some time? They did that. She wanted more. But she's like, well, I told them I had suicidal thoughts. And I said, every day you come to work and you have a really bad day. You're like, I'm so stressed out. My anxiety is on 1,000. But I don't have anxiety. I'm not diagnosed. It's just that's what I feel that day. So I had to explain to her that maybe, that's how they took it, but then educate her and say, I have been diagnosed with this, or I have been diagnosed with that. And this is really, this job, you are causing it to become worse. But she didn't do that. Because I really did think that she had a case when she said, I've done this before, and she showed us emails.
Yeah,
But
that's a tough one.
it was a tough one.
But they have to be able to prove that the reason that they've offered, it's not only is it not true, but the discriminatory reason was the real reason for it. And that's a really hard burden to carry. And that's why, McDonnell Douglas is highly criticized, by all courts across the board. It's hardly any court that thinks it should continue. And I know, after the Bostic case dealing with LGBTQ rights, a lot of people read that case to get rid of McDonnell Douglas. But there have been a couple of cases since then in the district courts. The district courts have said, no, McDonnell Douglas is still alive and well after Bostic. So, and then there was a case last year that was appealed to the Supreme Court that would have gotten rid of McDonnell Douglas, and the Supreme Court denied certiorari on that case. So they're sending a message that no, we're not ready to get rid of McDonnell Douglas, even though it's super highly criticized. So when we're talking about the prima facie case under McDonnell Douglas, what the employer must show is that they're a member of a protected class, they're qualified for that position with or without reasonable accommodations, that they suffered an adverse employment action, and that the unfavorable action was based on a protected trait. So it's not hard for them to make the prima facie case, which is the first step. And the courts have said it shouldn't be hard for them to make a prima facie case. But it's when they get to that pretext that it just becomes super, super difficult for them. All right. And so when we're talking about disparate treatment, you can either offer direct evidence of discrimination, which goes under a different analysis. We don't apply McDonnell Douglas. We go back to what's called Price Waterhouse. And that's just a typical burden when it comes to direct evidence. But when we're doing indirect, which is also referred to as circumstantial evidence, and that means that it's an inference of discrimination that is being raised in the case, and that's what most of our cases are. That's where the McDonnell-Douglas comes into play. And again, once you're dealing with summary judgment, what the courts have said is that McDonnell, again, it's constantly evolving, so you also have to be very careful if you're doing legal research, and how far back are you going? Because if you go back too far, you're going to find a whole bunch of cases that are applying McDonnell-Douglas to summary judgment. But there was a shift, and that shift came, probably around 2008, 2009, is when the court starts saying, no, McDonnell-Douglas isn't the appropriate framework when we get to summary judgment. So you have to be careful when you're researching the case law. And we're saying that when you're dealing with summary judgment, the correct framework is whether the defendant took an adverse employment action against the plaintiff and was a protected characteristic a motivating factor for the employment action. That's enough to take it to trial. Doesn't mean that discrimination occurred, because the issue at summary judgment is there enough for this case to actually go to trial? And they're saying you don't go through the whole McDonnell-Douglas analysis when you're talking about summary judgment. All they need to show is there's an adverse action and that the protected trait was at least a motivating factor, if not the sole factor, to survive summary judgment. And again, courts of appeals do not like summary judgment in administrative hearings, so you need to make sure if you're going to grant summary judgment that it's a really, really weak case that the complainant has. And so when we talk about surviving appeal and what the standard of review of these cases are when they go to the Court of Appeals. And again, we're going to rely on the Administrative Procedures Act. That's what the Court of Appeals uses in reviewing administrative decisions. And this is the citation to the federal APA as well as the DC APA. And to satisfy the requirements of the Administrative Procedures Act, a final decision must state findings of fact on each material contested issue. Those findings must be based on reliable, probative, and substantial evidence, and the conclusions of law must flow rationally from the findings of fact. And then the other standard that the court applies is called arbitrary and capricious. And again, a high level of deference when you're dealing with the arbitrary and capricious standard. And the case is, these are all of the reasons that a court would reverse an administrative decision. It's an abuse of discretion, contrary to law. You didn't follow the right procedures, that's reversal. Unsupported by substantial evidence. That's the majority of cases that get remanded. And almost always in an administrative case, a reversal results in a remand. Almost never will a Court of Appeals make the ultimate decision. In one of these cases, they're going to say this case is unsupported by substantial evidence. It needs to go back to the administrative law judge because we can't fill in the facts that they left out. So they need to go back and do it again. So it's almost always going to be a remand from the court. And the standard for all administrative decisions is that a Court of Appeals will affirm an administrative court's decision when it's made findings of fact on each material contested issue, substantial evidence supports it, the conclusions flow rationally from the facts. So that's why our decisions tend to be pretty long. And that's because you can't just address the issues that you found to be true. You have to address the issues that you found to be untrue as well, because those are materially contested issues of fact. So I've got to explain to the Court of Appeals why I believe something and why I didn't believe something else. And that's what makes administrative decisions so much lengthier than trial court decisions, because they don't have to do that in a trial court. They don't have to explain why they discredited testimony, but we have to explain why we discredited some kind of testimony. And so the standards of review, when it goes before the Court of Appeals, they go anywhere from de novo, like summary judgment. Summary judgment is always reviewed de novo. So the court's going to review summary judgment without giving any deference to the findings of the commission or to the administrative law judge when looking at summary judgment. And abuse of discretion, it means that it's going to be clearly unreasonable. Clear error, and that's applied to factual findings, arbitrary, capricious, and substantial evidence that we talked a lot about this morning. And again, substantial evidence, extremely deferential. And what the courts have said is that a reviewing court must uphold the agency's finding unless the evidence presented would compel a reasonable fact finder to reach a contrary result. And because substantial evidence means such relevant evidence as a reasonable mind might accept as adequate to support a conclusion, we reverse an agency's decision only when the record is so compelling that no reasonable fact finder could fail to find to the contrary. That's a very, very, very high deference that you get. And then de novo, again, is going to be really just summary judgment. We already did abuse of discretion. I think are we almost out of time, so I'm going to speed up a little. And so when does a board or a commission abuse its discretion? If it doesn't apply the right law or it rests its decision on clearly erroneous findings of fact, that's abuse of discretion. If they rule in an irrational manner, they make an error of law, the record contains no evidence to support the district court's decision, or they did not adequately establish the reasonings employed to reach a discretionary reason. Those are the reasons that the court will reverse a decision. And I'm going to quickly go through administrative decision writing because I see we're out of time. We issue proposed decisions, and then that goes to the parties file exceptions and objections. We address those exceptions and objections, and then it goes to the tribunal of 3 commissioners to make a final decision, so the ALJ presents the case to them. And so just a couple of things that I would encourage, if you're a new commissioner or a new judge, is to read as many cases as you can dealing with discrimination, because read it for style, read it for content. It really, the more you read the cases, the better it helps you in writing your own decisions. Always include a summary of the proceedings. The court really likes to have a nice, concise summary of everything that's happened prior to the hearing, procedural history. Use templates, adopt some language and law, but always keep those up to date because the law is constantly changing. Now, I oftentimes see people haven't updated their stuff in a long time and they're citing cases that have been overturned and overruled, and you don't want to do that. So you always want to keep those updated. Always have your writing checked by someone else, and always focus on the major thrust of your case. And when you're structuring your findings of fact are the heart of your decision. You should be spending most of your time on your findings of fact. That should take you twice as long to write your findings of fact than it should take you to write your conclusions of law. Because your case turns 100% on your findings of fact. Because again, the conclusions of law are going to flow rationally from those findings of fact. So make sure you're putting your effort into those findings of fact. And even though I do ask for proposed findings of fact, I never read them until after I've written my own. Because you don't want to be swayed too much by the party's assessment of the case. And you want to be careful because if you blindly adopt their findings, you blindly adopt their mistakes as well. So I always write my own findings of fact, and then I read the party's proposed findings of fact to see if I missed anything, or to see if do I want to rethink anything? Did they bring something up that I'm like, maybe I should go back and listen to the record on that? That's where the proposed findings of fact really, really, really help me. You want to explain why contrary evidence is being discarded or rejected. Very, very important for the Court of Appeals. Why did you find them not credible? Why did you not admit this into evidence? They really want to know that information. And remember that facts are only those that you found to be true. Facts are not a summary of testimony. Your facts should never read, so-and-so testified to XYZ. Your facts are, you have found this to be true. This happened on this date. That's a fact. That's what I found to be true. You don't say, they said this, but he said that, but I believe this person. It's only what you found to be true. I suggest you number your paragraphs. It just makes it a lot easier for flow. It makes it a lot easier for review by the Court of Appeals. They like it that way. And what the Court of Appeals has said is that an ALJ must include a narrative discussion describing how the evidence supports each conclusion, citing specific facts. The ALJ's logical explanation is just as important as the finding. And so when it comes to your conclusions of law, again, they should inevitably flow from the findings of fact because you spent so much time writing those findings of fact. You must address the quantum, which is your quality and quantity of evidence. You never treat evidence as non-existent. Identify the weak evidence, put it out there. This was weak, I didn't credit it, but it was mentioned. but don't ignore any evidence that comes in. You must cover the legal principles and relevant provisions of the statute, and you must be consistent with your findings of fact. And lastly, I have a few more, but I know we're out of time, so I'm gonna end. For what our rule says is that our commissioners, they can accept, reject, or modify the proposed decision. But if the commission chooses to modify the administrative law judge's decision, they've got to explain why. And they've got to be very careful when it comes to credibility determinations. The Court of Appeals feels very strongly that the person who heard the evidence is in the best position to judge the credibility. So you've got to have a really, really good reason for rejecting the credibility findings of the administrative law judge. You can do it as long as you've got a really good reason and you've explained that reason in the decision. And with that, I'm going to end. I have a couple more, but not too much, but it'll be available online. And I thank everybody for your attention.
Thank you.